a whole problem actually for companies in that space. How do they deal with that if there's no lead actually from the Sector Charter Council itself?
Okay, I see we've had quite a few more participants joining. Welcome, everyone. We're just going to wait a few minutes more to get everybody on board, and we'll then start with our presentation. Anton, just a few other developments. So the draft amended property sector codes, there's been a document that's been around for quite a while. And initially, the anticipation was that the amendments to the property sector code would come through quite quickly, but we haven't seen that coming through yet.
No, we haven't seen anything. And I guess lockdown and everything had its impact actually on the operations of the property sector council itself as well. So hopefully in the next few months, actually, let's say from January onwards, actually everyone is actually planning now for January. Everything will be new. Let's hope that's the case, and let's hope that we can see some more developments in that space.
Yeah. Okay. I think maybe let's get started then. I think most of the participants have joined. Welcome everybody. It's Eric Ackroyd speaking, and with me I have Anton van Geest and Malefase Madiba. We've also got Sean Kinnear and Adolf Jonker in the background. They're doing our technical bits. I'll do the first part of the presentation, and Anton will follow, or rather Malefase will then take over with a few sections, and Anton will cover the rear end. Just as some admin matters, we're going to be using the questions and answers facility on your toolbars. So if you could please post all your questions or comments in that toolbar, we can see them as we go along, and we will address them either at the end of a particular section, and we can also carry forward some to the end of our presentation. So right at the end of our presentation, we've got a Q&A session. So we'll cover all the matters during that session. Just as a start in the content of our session today, firstly, I'll go through the process for developing a sector code and what this means to the legal industry. We'll cover some general concepts, the different types of scorecards. We'll talk about the affidavits and the scorecards for qualifying small enterprises and large companies. And then we'll go through all the different elements in the legal sector code. You'll see that we talk about procurement and supply development, so they don't have a particular enterprise development element. And at the end of our sessions, each of these sessions, we will just touch on some of the matters that we feel should be included in commentary to the Sector Code Development Steering Committee that's in charge of coordinating and driving the development of the sector code. Looking at the process for developing a sector code, the practitioners in the industry have been through a number of different sector codes. There's a whole host of sector codes, and there's a certain process that needs to be followed. So currently, the legal sector code is subject to the amended generic codes of good practice. So there's not a specific set of rules for the legal sector code. What this means is that we can apply and we can do the affidavit, for instance, for when a company is under 10 million revenue and above 51% black ownership, it's a level 2 affidavit. If it's 100% black ownership, it's a level 1 affidavit. So those rules count for attorneys, advocates at the moment. Once this legal sector code is gazetted under the Section 9(1) of the B Act, which is the same level of, let's say, legal status as the amended codes of good practice or any of the other sector codes, then the legal industry and the defined scope of entities must apply this sector code. One does not have a choice other than measuring and applying the rules of the sector code. The benefits of a sector code is that it considers the particular sector's nuances, objectives, and the nature of the businesses in the sector. So it would be a set of rules that leads to a more effective outcome in terms of transformation that better suits the industry. And I think from that point of view, it is something that should be embraced and adopted and supported. With participants and the industry participating in the development of a sector code, it would also by nature be better supported and adopted and embraced. And that's very much the objectives around the development of the sector code. Unfortunately, in the past with sector codes, we haven't seen a transitional period. So we haven't seen that there's a specific period of time where there's some leniency in adopting the sector code. The rule that the DTI has enforced is that as of the date of the gazetting of the sector code, any affidavit or BE certificate that is issued on or after that date must be on the new rules, which typically doesn't give an entity a lot of time to plan and ready themselves for the new set of rules. The response on applications to have a transitional period or a longer phasing period has always been from the DTI to say that companies are aware of the draft legislation and they've got the time during the process of development of the sector code to start readying themselves. Now, we do understand that there is a request that a transitional period be included, and we would need to wait and see whether that comes through into the final legislation. The Legal Practice Council established the Sector Code Development Steering Committee, which runs with the development of the Sector Code. And amongst others included in this process is the Black Lawyers Association, the General Council of the Bar, National Association of Demographic Lawyers, Pan-African Bar Association, and then Advocates for Transformation. Those just being some of the stakeholders that are involved. And the more involved the industry is in terms of the commentary period, the better that sector code can align to everybody and to the industry. There is a request for comments on the paper that we're going to be talking through today. There's I do have the email and the dates on a further slide, but comments can be submitted to the legal sector code at lpc.org.za by 15 December. So I'll show a slide a bit later whereby you can just record that, and we really do encourage that commentary is collated and given. Alternative Prosperity will also be submitting comments, and I think what's important for us is that today that we get comments and thoughts from our audience that we can also include and include in our commentary. The scope of application, in other words, who's affected by the legal sector codes, it includes practitioners in private practice, so attorneys, advocates. It includes legal practitioners in the private sector, paralegals, non-profit community-based organizations, and then corporate entities in the private sector, where such an entity procures legal services. One of the challenges we foresee on one of our comments is that how would one deal with a entity, let's say an Investec that has both a legal department and the normal business, and they get measured on the financial sector code, but there's an expectation that their legal department also does a legal sector code. And exactly how will we deal with that BE certificate and what would it be used for? So those just some of the questions coming out of the proposed scope. Also included in the scope is Legal Aid South Africa, and then government departments that procure legal services, and university law clinics. So quite an interesting scope. And I think where this departs from the usual sector codes is that we are looking at legal departments or business units within a larger entity that is included in the legal sector code scope. process when developing a sector code is firstly that a Section 12 of the B Act Transformation Charter is designed and gazetted. And this is very much gaining the commitment to transformation of industry bodies. At this point in time, we are still at a stage before the Section 12 gazetting. We at a stage where there's a draft document that is the start of the proposed legal sector code. So it's a very fluid document at this point in time. We understand that once the comments are received on the 15th of December, it is envisaged that a next draft is issued then towards the end of January, early February, and that the process would then continue leaning towards the Section 12 and the Section 9.5 gazetting. So what the next stage of Section 9.5 gazette means is that it is then open for public comment. And there's a 60-day comment period, after which the comment period closes, and the Sector Code Development Steering Committee would then go through all these comments and process them, and then gazette a final sector code, which would then be binding. So we really encourage participation during this forming stage of it in order to ensure that the codes are practical and implementable. In developing a sector code, there are certain rules that need to be abided by. The first thing is whether a sector code is feasible. Does it make sense? And in order to establish that, there needs to be common commercial and characteristics within the sector that supports that sector can stand alone, and they should not be measured on the generic codes of good practice. The second aspect is that all the elements in the generic scorecard need to be addressed. So you can't leave out certain elements unless it is, let's say, in the case of the property sector code, where you have certain property owning companies that don't have any employees. It has been allowed in those cases, but in all other cases, it is required that you can add additional elements, but you can't take away elements out of the generic codes when you're developing a sector code. Definitions need to be similar, so your definitions around voting rights, procurement, all these need to be similar definitions or the same definitions, and the basic calculation methodologies need to be the same. Targets and weightings can be different, and we can then also have higher targets but not lower targets in a sector code. And then also the scope of application needs to be very clearly identified. Okay. All right, and then support from line ministry, very important that we have support from line ministry. And then also, if we look at the role of the Sector Charter Council, their role is to liaise with relevant stakeholders to facilitate the implementation, and then also to provide guidance and to monitor how the implementation is going. And we also have the Sector Charter Council playing a role whereby entities need to submit their BE certificates and their verification reports on an annual basis. And these are then summarized and reports are released whereby the progress of transformation in the sector is reported on. The composition of the Sector Charter Council is established. It is established by the Minister of Justice and Constitutional Development, and then typically you would have industry bodies involved as well as government sitting on the Sector Charter Council. We'd like to run a poll. Sean, if you could just set up the poll for us. If we could just ask you to participate in this poll, it will help us to understand our audience a bit better. What is your role in the industry? Are you an advocate, an attorney in private practice, a legal advisor working for a company, a BE consultant, or any other? Sean, if you could just confirm that you're running that that poll.
So Eric is running, and we're looking at the second one, an attorney in a private practice, about 70% of our audience, and BE consultants, 11%. It's still moving around, and now it's changed. Got some other positions being held, 20% of them. But yeah, attorney in private practice is 70%. It doesn't seem like we've got any advocates on board, and BE consultants about 10%.
Okay, so it's very much the kind of composition we expected, whereby this has got a big impact on attorneys in practice, and also around quite a big impact on advocates. And then for the consultants, we're always glad when there's new legislation, because it gives us something more to do and something new and interesting. So we're looking forward to this process. Just a couple of general concepts that are contained in the sector code. Similar to the generic codes, the key fundamental principle is that substance takes precedence over legal form. And what this means is that where there's a transaction or anything, that what actually happens is more important than what seems to have happened. And also that where a transaction is being done purely to get more BE points, but not considering the impact of that or any commercial aspects around a transaction, there may be a substance over legal form issue that needs to be considered. The other key principle is that the objectives of the BE Act needs to be kept in mind when interpreting legislation, and it needs to be aligned and supporting the overall objectives of BEE. Similar to the generic codes, where an entity is split up in order to ensure that it is an exempted micro enterprise or a qualifying small enterprise, and it is purely done for that intention, that will constitute a fronting offense and is not allowed. So this is some of the basics that are applicable to all sector codes and the generic codes. The BStatus Matrix is not in particular specified in the draft code that we've looked at. However, where the code is silent, the generic codes of good practice prevail, and we point back to the BStatus Matrix as per the generic codes of good practice. And just to touch on what this means, in the middle column is your number of points that you score on a scorecard. That would determine your BStatus level, for instance, a level 6, and that would then determine your procurement recognition percentage, the 60% procurement recognition. And what that means to a customer of yours means that if they spend 100 rands, they can count 60% in their procurement scorecard, which is then 60 rand. So that's the relevance of this BStatus Matrix. For attorney firms, and we're going to split the scorecard between attorney firms and advocates. For attorney firms that have revenue of under 5 million annual revenue, they are exempted, and this exemption is qualified. What it means is that where you've got attorney firm is under 5 million revenue and they have less than 30% black ownership, they will be a level 4. Where they are between 30% and 51%, they'll be a level 3. Then 51% to 100 is a level 2, and 100% black owned is a level 1. And the method of calculating this black ownership is the flow-through method, which means that in an example where you've got a company that is 51, or let's rather say you've got 51 black partners, and then that would flow through immediately. So let me rather use the example of a company. So where you've got a 51% black owned company that owns 25% in a measured entity, normal flow through means 51 times 25, which is 12, and that is the measurement. So it's the effective calculation method and not the modified flow through method. Now, over and above the black ownership requirement, the exempted microentity is also expected to register a black female candidate attorney, or to have 2 designated learnerships registered, or to contribute to 2 bursaries at a tertiary institution. So that's an additional criteria. And where this criteria is not available or possible, then they are expected to train paralegals or legal secretaries or any other suitable training that has been approved. Okay, so it's not just only the black ownership, but there is also the additional requirements and expectation. With attorney firms between 5 and 10 million, they are partially exempted, but they must comply with one of the 3 priority elements on the scorecard. With companies or attorneys between 10 and 60 million, there's a qualifying small enterprise scorecard, and they need to apply this scorecard in their verification and their certification. And then where there's revenue of greater than 60 million, there's a large entity scorecard. And we'll go through these scorecards during the course of our presentation. For advocates, the exempted ranges between 0 and 3 million. And that at this point is only defined as exempted. We have a few comments that we'll discuss around that. Then revenue between 3 and 10 million, they are partially exempted, and they need to comply with one of the 3 priority elements: ownership, skills, or procurement and supply development. Or alternatively, they must facilitate training of black beneficiaries. With revenue of more than 10 million, they need to comply with each one of skills development, procurement, and supply development. And in addition, they need to enroll a designated junior counsel or a designated pupillage. So as mentioned, these codes are very much in draft and in the forming stage. So there are a number of questions around how do we practically implement this, and how do we practically go and measure these criteria, and how do they translate into a BE status level. And these are some of the comments that we are feeding back during this period. If we look at the attorney's scorecard, the qualifying small enterprise scorecard, we can see the weighted points on this slide, and the heavier weighted elements are preferential procurement at 22 points, and then skills development and ownership at 20 points, also quite a strong weighting. And it certainly makes sense to have a higher weighting on skills development, which is really an area where a law firm can make a big impact in terms of transformation. We look at the large entity scorecard, we can see skills development being quite a weighted element at 27 points, followed by preferential procurement. And the preferential procurement is quite an interesting element in this case, where it's very different to the other sector codes, and Anton will take us through that in his slides. The scorecard for advocates that have a revenue of more than 10 million. There's no ownership quantitative score, but rather there are certain qualitative requirements that we'll run through. And then management control and employment equity, as well as skills development, are excluded at this point in time. Then also a high level weighting on preferential procurement at 28 points. And then supply and socioeconomic development also points to be scored. And we are expecting quite a number of changes to this going forward. But I think this is a very good idea of where the sector code is heading. So as mentioned earlier, comments can be submitted by 15 December to legalsectorcode@lpc.org.za. We are going to distribute these slides after our webinar, so you will be getting that information. And some of the questions that we have and comments that we have is whether an affidavit will still apply. The code is not talking about an affidavit. It is giving the different levels that can be attributed to different levels of black ownership, together with a qualitative requirement, often relating to the priority elements. And it may be that companies or law firms will be required to have a certification done, similar to in the construction sector code. So I think we need to be aware that affidavits are not necessarily going to continue to be applicable as they are in the current regime. Another question is around where we've got a company and they've got a legal department, and the company needs to be measured on either, let's say, a generic code or the financial sector code. And how will this legal department now get their own BE certificate, and how would that be applied in practice? Which is quite a question for us. The level determination of partially exempted entities,
Eric?
we're not quite sure. Yes.
Sorry to interrupt. We couldn't see your slides for a moment there.
Okay. Is that better, Sean?
Thank you.
Okay. Also, how will partially exempted entities level be determined? So there's this exemption that has been provided for if you have certain qualitative aspects in place, but we can't see how that is going to translate into a score or a BE status level. The advocate scorecard is out of 46 points. How will that translate into a level? And then the exempted entity level for advocates it's silent as to how that is determined. So some of this, all clarity required on this. And then also we are suggesting a transitional period, being that it will be effective for the first financial year commencing on or after the gazetting date, very much following on transitional rules that are applied in the accounting world. So these just some of our matters that we've identified, and please, any matters that you identify or questions that you identify, if you could post them in the Q&A function of the webinar. Right, just looking at the ownership element, with companies that have revenue of less than 5 million, we have the automatic level 1, 2, 3, and 4. So if you are a level 4, you don't need to have any ownership. So with 0 ownership, you can still be a level 4. So that is what is meant by being exempted from ownership. Where your revenue is between 5 and 10, you partially exempted from ownership, which means that you need to comply with any one of the 3 priority elements. And if you choose not to comply with the ownership element, it effectively means that you are exempted. The revenue between 10 and 60, and then above 60, they have a scorecard, and those being the scorecards that we looked at, where you have a traditional scorecard for your ownership points. If we look at the ownership scorecard, we've split it here on the left, or in the middle, we've got the qualifying small enterprise scorecard. And then on the right, we've got the large entity scorecard. There are 3 aspects that are measured. One being voting rights, the second being economic interest, and the third being realization points or net value points. Starting at the top, we see that we have a similar voting right target for your large and qualifying small enterprise. Both of these have a total of 20 points attributed to the ownership scorecard. On the voting rights, your designated categories are defined as Black, women, youth, and disabled. And then we've got a particular 20%, 30% target on voting rights for those categories. Economic interest for Black practitioners, there's a 10% economic interest target, which is a lot less than the codes of good practice. So that going a bit against the principles for developing a sector code. And we think that's something that will still develop going forward in the development of the code. And then also, interestingly, the designated categories target is higher than the 10% target of Black practitioners. So typically, we would see that we have, for instance, let's call it a 30% target for Black people, and then we would have a 15% target for Black women. So the scorecard is slightly different compared to that. And then we've got a realization point target of 15%, which is higher than the 10% economic interest target for Black practitioners. The code is silent as to the graduation factors or the gradual method of achieving these targets for net value or realization points. So that's also something that we still see developing going forward. But I think in essence, the measurement of Black women, Black youth, and Black disabled people is something new that's on an ownership scorecard. And then also the targets that are very different to what we used to. Just very briefly, definition of voting rights. That is a voting right that attaches to an equity instrument. We would need to see a unique voting right definition for partnerships where we don't have equity instruments. Then also our designated categories are defined as Black people, Black women, youth, and people with disability. So interestingly, Black designated categories are not defined, but designated groups are defined. So we are in need of clarity around the designated category definition. Yeah, and then economic interest, the standard codes of good practice definition is that it is a claim against an entity that represents a return on ownership, similar in nature to a dividend or a similar right. The scorecard for advocates under 5 million exempted, between 5 and 10 million partially exempted, but there are qualitative criteria. Firstly, that they need to comply with one of the 3 priority elements, and they need to take Black advocates as juniors or enroll designated beneficiaries as junior counsel or pupillage. So you've got your priority element requirement and then also additional requirements that are applicable. Under revenue more than 10 million, we have to comply with all the 3 priority elements, or take Black advocates as juniors, or have designated beneficiaries as junior counsel or pupillage, or interestingly, contribute at least 150,000 rands to a legal education trust for bursaries on rural students, Black youth, and Black women. So this is departing from the traditional way that the sector codes and the generic codes work, whereby there's a scorecard priority element requirement, and then also there's a requirement for a qualitative aspect. Some of our matters that we've identified is that in cases we've got a higher Black designated category target than we have for Black people. In cases the youth and disabled in terms of the designated categories is not specifying that it is Black people, and that would need clarification. And we're suggesting a definition for economic interest because we have sole practitioners, we have partnerships, and that begs a different definition to be practical. Also, in terms of the priority element, if you have achieved it in the partially exempted entity, what level do you get, and what happens if you do not achieve this? And then also just on advocates, it appears that there's no real ownership scoring, but it's only a qualitative measurement. And then how does that impact on a BE status level? Right, so I'm going to hand over to Malefase that will take us through the next set of slides. So Malefase, if you can take over the presentation.
Thanks, Eric. Good morning, everyone. Okay, I'll be taking over from here for the 2 elements being management control